Welcome to the Entertainment Ethics and Malpractice Year in Review, the Ethics Factor. I'm Keith Kelly, chair of the Beverly Hills Bar Association's Entertainment Law section. We have a few housekeeping items to go over before getting to the program. The Entertainment Law section is sponsored by Lawyers Mutual Insurance Company. For 5 decades, Lawyers Mutual Insurance Company has been the only California-based company to continuously provide lawyers throughout the state with professional liability insurance coverage. Their experience and expertise are complemented by the fact that they are directed by a group of dedicated lawyers. They offer special rates with competitive premiums for a wide range of areas of practice, including entertainment law. Learn more at lawyersmutual.com. I'm delighted to introduce our speakers, Aaron Joyce and Marshall Cole. Moderating today's program is Neville Johnson. Just quick bios for each of them. Aaron Joyce has extensive experience in state bar investigations and disciplinary proceedings, plus over 30 years of civil litigation practice. Aaron has over 25 years of experience handling all aspects of discipline cases against attorneys in state bar court, from the filing of complaint through trial and review. Aaron has comprehensive understanding of how state bar investigations and proceedings unfold. Before going into private practice, Aaron served as Chief Special Investigator for the Los Angeles Fire Department, as prosecutor for the State Bar of California, and as a lawyer for multiple private practices. Thank you for joining us. Marshall Cole is the managing attorney at Nemesek & Cole and a nationally recognized trial lawyer for his success in complex, high-profile professional liability and civil litigation matters. Named by the Daily Journal as one of California's top professional liability attorneys, he is renowned for his proactive, solutions-driven approach and consistent record of winning results at trial. Thank you. And our moderator today is Neville Johnson, a nationally recognized entertainment and media litigator and founder of Johnson & Johnson, widely regarded as one of the most formidable advocates for artists' rights in Hollywood. A Phi Beta Kappa graduate of UC Berkeley and a Southwestern Law School alum, he has recovered more than $350 million for actors, writers, and creators in royalty profit participation and right of publicity disputes. Designated as a legal legend by The Hollywood Reporter and a top 100 attorney by Super Lawyers, Mr. Johnson is also a leading authority on defamation and privacy law, having successfully litigated a landmark invasion of privacy case before the California Supreme Court. He brings exceptional passion to protecting creators while continuing to oversee all matters at his firm and teach entertainment and media litigation as an adjunct professor at Southwestern Law School. Over to you, Neville.
Well, thank you. And I should add that I have represented lawyers in malpractice cases, been an expert witness, and also prosecuted cases against lawyers. I'm going to make a couple of general comments before I turn it over to Aaron, who, by the way, I'll mention, well, when she was a state bar prosecutor, she prosecuted successfully a case against someone I was representing. Look, the client is not your friend. I always say this at the beginning of these. It's illusory, the relationship that lawyers have with their clients. You will be invited to weddings, bar mitzvahs, to go on vacations with the client, but at the end of the day, you're a fiduciary and you're not family to them. And I think we all have had experience that when the money comes in, any lawyer could have done that. And when the case goes south, it's all your fault, Mr. and Ms. Attorney. That's why fee agreements are so important. And I highly recommend you check out the seminar that is available for download that I did 2 years ago with Marshall Cole and another lawyer, called Complicated Ethics Issues in Fee Agreements, in which we cover a variety of topics such as contingent fees of more than 50%, changing fee amounts in midstream, taking a percentage of the client's income, arbitration agreements, and the like. We'll be covering some of that today as well. The big deal for entertainment lawyers are conflict of interest situations. Just know that when you have a wholly owned company for the client, that creates a conflict, and you have to advise them they need to waive it and give them the right to seek independent advice. And the other issue is referral fees overall. And I'm not going to get into the specifics of it, but you can make a lot of money and get into a lot of trouble with referral fees. And with that, I'm going to turn it over to Erin Joyce. Take it away.
Okay, give me a moment as I set up our screen share again. And let me just do I'll show from the beginning. Okay, are we good? Or are you seeing the wrong one?
We're good.
Okay, so sorry.
Okay, actually, Erin, can you switch the display settings?
Yep,
real quick?
I certainly can.
For swap.
Okay.
Yes, perfect.
Perfect. Okay. All right. So, yeah, we're going to talk about some of the recent happenings within discipline and professional responsibility area. And I do think it's bears discussing what Neville started with, is that your client today, I see them as complaining witness tomorrow. So how many times, and I'm sure Marshall can talk about this too, how many times would a case just be stopped in its tracks if the attorney took the time to dot every I, cross every T? And when you're under exigent circumstances, which by the way, are not your exigency, it's the client's exigency, that get lawyers to maybe not finalize that fee agreement in advance, or not secure that conflict waiver when there's more than one client, because you want to make sure you provide great legal advice, or even worse, when you don't document that important phone call with the email follow-up. That is when it takes longer to resolve a State Bar complaint or deal with potential legal malpractice. Because as Neville said, I think this is absolutely true. If the great result that they always wanted and expected occurs, there's a sense of, oh, well, that's just what's supposed to happen. So there's some gratitude, clearly. And I guess a different program can talk about whether or not there can be a built-in kicker or extra bonus into the fee structure with that great result. That's really maybe beyond what we can talk about today. But if the case doesn't go well, it's not like the client or complaining witnesses has a lot of introspection. So it's practicing defensive law will solve a lot of the concerns and problems that you'll be facing later on. So we're going to talk today.
Yeah, real quick. And one of the real important reasons why is, it's all well and good when things go great, but I've got a ton of legal malpractice cases that I'm defending, some of which went through trial, and the result that was obtained wasn't very good. It wasn't necessarily a complete loss, but it just wasn't very good. And the clients are now suing lawyers saying, look, you should have saved me from myself, right? You should have told me I should have never gone to trial. And it's hard to think about in real time communicating clearly those types of details regarding someone's case. And so if you take a step back when you're representing your client and communicating with them, and I know we all text regularly, I would discourage texting clients anything of importance other than just some scheduling details. But you really want to lay out the good, the bad, and the ugly, because you just don't know how a case is going to transform over a period of time and potentially through trial if you're a litigator, and if not, even in a transactional setting, if a deal blows up. And the client then comes back and says, well, you didn't warn me about X, Y, and Z. And so it's really important to keep that communication ongoing and updated as things develop, as bad facts come out, and things that you may not think are necessarily bad are still worth communicating to your client, because down the line, you just don't know how, when people look at things hindsight 2020, how it's going to look when you didn't effectively communicate as you should have. And so if you do it on the front end, it creates a real easy defense if a client sues you for me to come in and help you out and get you out on a summary judgment motion or otherwise. Sorry about that, Erin. Go ahead and jump back in.
Oh, no. And just I would have said 5 years ago, don't text message with your clients. But then again, I would know you're not going to listen to them. Just like, there's a lot of great advice that maybe people can't follow. But if you're going to engage in text messaging with a client, you have to have a way to document it. And there are commercially available programs now that don't cost a lot of money that can document those type of communications. You can even build it into or a lot of these different case software does the same thing. It acts as a text message or instant message, and it documents those kind of communications, because you may be dealing with people on the fly on your phone, and that becomes, if it's a substantive communication about the case, it has to become part of the client file. You have to have a way to maintain it. So we're going to cover these topics here and maybe more. The new stability oath, we're going to talk about CTAPP and how the random audits are going. They're still underway, as far as I know, on the first cohort of 100 people. The MCLE audits that are going forward, they continue to move forward. We'll talk about some big discipline cases from 2025. We'll talk about, in the end of 2023, the State Bar's COPRAC committee put out AI guidelines, and they're basically underway to be revamped right now, because that technology is moving so fast. Most of what was said before really isn't as helpful as it could be. And the Supreme Court is actually asking for more guidance because of all the stuff that's happening in that area. And we'll end with some conflict of interest. So first of all, the State Bar spent, with their Blue Ribbon Commission between the California Lawyers Association and the California Judges Association, putting together, not just guidelines, but new rules of professional conduct to basically require something like civility, whatever that means, from practitioners both in the transactional and litigation setting. And they sat with the Supreme Court for a while, and this has happened more than once. This is not the first and only time this has happened. The Supreme Court determined they're not viable. So the only thing that was actually adopted is that we all, in the connection by April 1st, are going to have to renew or take for the first time the civility oath that new lawyers have had to do in the last couple of years. That's not to say that civility has no place in the practice of law, clearly not. And there have been some really pretty egregious cases in the last couple of years where lawyers really took it in the chin by increasing the cost of litigation because of their incivility, and having their attorney's fees award gutted even if they won. So so it's not to say civility doesn't matter, but the potential discipline from civility, which was kind of hanging over practitioners, that has been at least averted for now. They're back at the drawing board, though, with trying to come up with something that would pass muster in that area. So
I think it's really important, regardless of a rule or not, to read this and adhere to it regardless. Being uncivil to your opposing counsel does not look good at any point in time during litigation representation. Of course, bad emails are going to make their way in front of a judge. Nobody's going to look good, neither the person submitting the email nor the person who wrote it. Either way, it looks bad. And of course, down the line, if a claim arises and you're a defendant and these types of uncivil emails firing back and forth, it just doesn't help the situation. And most importantly, at no point in time are you ever advancing your client's interests if you're just getting into it with your opposing counsel and hurling personal attacks. Or if you're on the receipt of those personal attacks, don't engage. You just need to take the high road and let it fly and recognize that you're being the better person throughout that process, and you're ultimately protecting yourself down the line.
What I say in a deposition, if they come after me, is I say, that's a personal attack, and then I just ask the witness to answer. And the sixth time I say, that's your sixth personal attack. In accordance with the principles of Mahatma Gandhi, I reject your personal attack, but I will not answer it. And at that point, everybody starts laughing. And he looks like, or she looks like a fool. So the bottom line is, do not get emotional. Courts, judges hate it when you get into with each other. We're all advocates and we have emotions and we want to win, but the key is to operate with equanimity and kindness.
And one other point on that. you can, and I would strongly suggest you consider putting into your fee agreement in the section where it talks about, attorney's duties and then it pivots to the client's duties. You put in there that decisions with respect to scheduling and reasonable continuances are the purview of the lawyer in the context of the civility guidelines. Because sometimes it might be the client that thinks they want the bulldog lawyer, at least until, the end of the case, when it costs them so much more. So yeah, you can start managing the client's expectations about civility from the very beginning in your fee agreement. So let's talk a little bit about, here we are looking at the 4th year where all lawyers have to, under penalty of perjury, appear to the State Bar that they are in full compliance with Rule 1.15 of the Rules of Professional Conduct and all the CTAPP rules, Client Trust Account Protection Program. And last September, they launched their first set of compliance reviews. They're supposed to be random-ish, but not random like everyone's name is in a hopper. It's random in that they want to have, based on everybody that has to now identify what your practice area is, at least your number one practice area, and size of your firm. They're trying to have a representative sample of lawyers that are subject to these compliance reviews so that they're not heavily weighted only, as they normally are, on small firms. So I can tell you that they have not completed, as far as I know, any of the audits that started last September. I can tell you that only 4 CPA firms in the state of California went through the vetting process that are available for the lawyers to hire for these audits, because you, as the cohort or the unlucky lawyer that gets, or law firm that gets chosen, you're the ones that you have to pick one of their CPAs in order to go through this process. So according to the attorney on division regulation, they're going to be expecting to do about 400 audits each year. So after April 1st of this year, they'll pick the next 400. And I think they're really doing a lot to calibrate how to do the audits with respect to this first 100 that are going forward right now.
And to put some relevancy on the issue, I'm in a trial right now. In about 45 minutes, I'm going to start cross-examining a partner of a law firm, and several of the questions, though it's not an ethics-related trial, are going to be touching on CTAPP compliance and when the rules came into effect and knowledge of those rules. So this is relevant in many areas, separate and apart from just your State Bar compliance. Just with respect to your governance and management of your law firm, it's important to comply because these issues are coming up and they're going to be very important for this particular witness in about 45 minutes.
Well, another thing that's important, and I got a lot of people, consulting with me about this issue. And I can say, like anything else, when it's new, it's going to be kind of glitchy. So the State Bar profile screens on CTAPP are really glitchy. They've gotten them a lot more smoothed out, streamlined. The questions and the self-assessment, they've certainly made a lot better. They're more understandable to lawyers. I mean, all of us have advanced degrees, and many people didn't understand those questions. But I can tell you, having looked at the questions again for this year, which are very similar to last year, because they kind of dialed it in as of last year, those self-assessment questions are basically, all you're doing is you're saying, yeah, I know what the rule is. I know what the particular requirement is. You're not averring that you 100% follow the policy all year. So if it turns out, as an example, that in one case during 2025, you didn't notify every single claimant of the receipt of the money within 2 weeks, as what the rule requires, as long as you have that policy in your office and you are aspiring to do that, really trying to do it, you have policies and procedures in place to do that, you can feel comfortable saying yes to those questions. Because a no is going to get an audit. You cannot be in compliance without certifying CTAPP compliance. There's no such thing as certifying non-compliance. And just to let you know what happens internally in the State Bar is basically taking a more regulatory approach rather than simply not instead of, but at the same time as they're taking the discipline approach. So the first thing that happens if you have problems with CTAPP is they assess, just like anything else, any kind of non-compliance. They assess a fee And then you have to pay fees to get reinstated. And if you let it go long enough, as of July 1st, you're going to go on an inactive status. And you might think, okay, that's all regulatory. That's all automatic. But non-compliance can be referred to the discipline side of the State Bar, which is the Office of Chief Trial Counsel, because the CTAPP compliance is all basically centered in the Division for Attorney Regulation. So it's a new regulatory, not new. It's what used to be member services is now becoming a much bigger part of the State Bar. That's where your all of everything that goes through the State Bar profile, including renewal of your professional law corporation, et cetera, is now, along with the audits, going to be in the regulatory function in the Division of Attorney Regulation.
Hey, Aaron, we got an interesting question. I don't take retainers and only bill for services already rendered. I am not required to have a client trust account, correct?
I would say if that were 100% always true, then that would probably be correct. That does not obviate your obligation to still do the self-certification. And here's the thing, many lawyers are freaked out by, oh my God, all these CTAPP rules. And they've like abandoned their trust accounts, which, by the way, if you open or close a trust account, you have to notify the State Bar within 30 days on your State Bar profile. It doesn't really save anything. Once you get yourself into compliance, it's not that hard to stay in compliance. And what happens if you get that one-off case that you want to take an advanced cost on, like an expert fee, et cetera? You have nowhere to park that money if you don't have a trust account.
Yep.
So it's a very dangerous thing not to have a trust account. And it's not that hard.
Yeah, I think it's not that hard. You can have it, don't use it. You might get a settlement. The money's got to go somewhere. It's the easiest place to put it. And I've defended State Bar matters where clients didn't have trust accounts claiming the exact same thing. I don't have money that flows through. And it's just still creates an issue because it's a rare circumstance for a lawyer to be in. So there's really no downside in having it.
Yeah, once you get yourself into compliance, you're going to be fine. The other thing is this year, 2026, every financial institution that maintains trust accounts needs to have on record now who is the licensee, at least one lawyer that's responsible for that trust account. So you're going to have to do a special form this year for every trust account associated with your firm. Okay, and if you do get selected, the audits basically go back 1 year. They go back through the compliance period, which would be January to December of the year. Like, so for this, once you do your certification by April of this year, it'll be for 2025. So you want to make sure before you do that certification, you at minimum have the required records in place, meaning an account journal. And then if you have an account journal in Excel or anything, pretty much, it will create a client ledger card because each of the transactions for the year are keyed to an individual case. And so you just want to filter, and that creates the client ledger card. Almost nobody maintains a separate client ledger card anymore, like they had 20 years ago. It's just a report in your online software. And if you get, unfortunately, if they find any problems or big enough problems, they can expand that 1 year look to 3 years, according to the CTAPP guidelines. So you really want to be careful. We're going to spend 1 minute on MCLE compliance. The auditing of MCLE is also in the Division of Attorney Regulation. And thankfully, they've now moved this to be a more regulatory rather than disciplinary approach. So if you get selected, you'll just have to be able to provide your certificates for the 40, for the 25 hours in the different areas. And whereas initially the State Bar was coming out guns blazing in 2011, looking for actual suspension for people that had MCLE non-compliance. I'm not saying it's a good thing. I'm just saying now they're trying to make it a regulatory approach. And you could really, if you are an active lawyer, you need to basically ensure you keep your certificates. The State Bar is trying to move to a system where it's going to be the MCLE provider directly provides information to the State Bar, but that hasn't happened yet. So Before we get into the other beefier parts, I want to talk about a couple cases that came out of 2025 in the State Bar area. And they do have application. One thing I could tell you is that while the number of complaints that hit the State Bar have steadily, we kind of leveled off now, but once they made an online portal, the number of complaints coming in has increased. It's like 16 to 18,000 complaints come in a year. But the number of cases that make their way through State Bar Court is very steady. It's like the same, you have the same 5 judges, not same exact people, but 5 slots for hearing department judges as they did when I started back in the 90s. The number of cases in discipline, either by a disciplinary stipulation or a trial in State Bar Court, has remained remarkably steady. So the truth is, what's the difference? The difference is the number of cases that are closed, the percentage is higher, actually. The percentage of cases that come in as an investigation are higher, and I would say the backlog has increased. That's what's happened. So what do you do if you get a State Bar letter? Chances are it's going to close. So that's a good news. Here's another thing that I could share with you. A lot of times, because the investigators are such a new cohort, it's a revolving door in the Office of Chief Trial Counsel. They're not really highly experienced. So most of the investigators, since they can't just share with you the complaint that they received, because the complaint and everything in an investigation file is confidential, they have to kind of summarize it when they reach out to you. And they're not really going through and letting you know what makes sense and what doesn't. They're not really assessing it at all. They're literally just kind of regurgitating what the issues are. So don't get your back up and think, oh my God, I can't believe they're accusing me of this and that, and get really upset. That's coming from the complaining witness. They don't have any dog in the fight as the investigator. They're just as happy with the closer as they are moving the case forward. So your response should be measured, professional, and honestly, probably through counsel.
I was going to say, if you want to handle this on your own, it better be really, really simple and straightforward. Otherwise, call Aaron, call me to walk you through it and assist you. And a lot of times your professional liability insurance coverage is going to have a rider in it that will cover State Bar matters. It's sometimes a no deductible 25,000 limit, 50,000 limit, whatever it might be. You should use it. And if you don't know whether you have it or you don't have it, the next time you're up for a renewal, you should inquire as to whether you can get that, because as Aaron said, there's so many more referrals. You're going to get a letter that says your State Bar license is at risk, but it might be shut down relatively quickly. It's going to cause you a lot of stress. And if you have that coverage, someone who's experienced in the field will take care of it and hopefully get it shut down right away.
Exactly. And I think that the problem when you try to respond on your own are twofold. One, a lawyer gets their backup and they get aggressive with the investigator and they withhold necessary information. And the last thing the investigator wants to do is have to touch that file more than once. They just want to be able to send out the letter to you, send out the letter to the complaining witness asking for more information. If there's something to do with the court file or something to do with the account, they'll send out the subpoenas for those records. They want to look at everything once and write up either the closing memorandum or the investigative report. If they have to get into a back and forth to get more information from you, chances are, first of all, you're making it harder on them, which is never good for any agency. And also you're making it more likely that the case, if they're confused, this is unlike anything else you've ever seen. If they are confused and they're not sure, unlike in other normal circumstances where you might think, oh, they may not think they have their case, they'll close it. No, if you don't make it crystal clear why they should close the case, it will move forward. So it has to be super clear. So you don't withhold information. But then again, on the other side, sometimes lawyers feel like they have to give too much information. And if you give too much information, guess what? You opened up other areas of inquiry that they can't close the case. They have to follow up on that. So you need to calibrate the response. And that's why if you do it through counsel, it probably makes more sense. Now let's talk about some of these cases that did come out of State Bar Court and through the process this year. The Bradshaw case actually was a Supreme Court case. And that happens so rarely because the only time a discipline case the way to the Supreme Court is by cert. It doesn't happen very often, but in Mr. Bradshaw's case, he did. And this is a case that bounced around with a lot of procedural, nightmare in the proceedings before the State Bar Court. But basically, the Supreme Court found that he was engaging in conflicts of interest in the context of a conservatorship and with respect to a fixing up a house up in this Bay Area for a woman that wanted to stay in her house and not move into assisted living. And so, as far as I understand, reading the file and seeing some of the earlier case law, write-ups of the case, it was really this attorney, spending a lot of money to try to keep a woman in her house when she didn't, she wanted to stay in her house, but the rest of the beneficiaries didn't want that money spent. And some of the contractors he used, he may have had an interest in. So the Supreme Court found he was disbarred. So conflicts of interest are really, especially if there's any financial issues, they're no joke. I mean, the Supreme Court took a much more harsh view than the State Bar Court did, and even at the review department level. Okay, so this one is another case that came out of the review department. In the State Bar, we have 5 hearing judges, 2 up north and 3 down south in LA. And then we have a special review department that handles all the appeals. And then you have an appeal as a right to the review department and only by cert to the Supreme Court, which happens almost never, very, very rarely. So this case Mitchell stands for the proposition that anytime you have any actual suspension, it triggers California World Court 9.20. 9.20 says that if you have any actual suspension, it used to be at 90 days actual suspension, but now it's any actual suspension. You have to notify every client, every opposing party or counsel by certified mail, keeping the little green card, return receipt requested, and file notices in every open matter. And it's that snapshot of your open files as of the time the Supreme Court order issues. Basically, the State Bar finds that a violation of 9.20 and along with a lot of other violations here, they take that as a disbarment level offense. So again, it is extremely serious. Now, this case, Tremarsh, is about a situation where this is one of the very rare instances where the bar gets involved in what looks like an advertising type of case. It happens almost never, because most of the time, if there's an advertising problem, the State Bar basically issues cease and desist letters and people correct their correct their actions. But here, this was basically a student loan debt servicing operation, trying to consolidate student loan debt. And it persisted. The attorney persisted after multiple, I guess I would say warnings. And that's why this resulted in a significant actual suspension. One thing I could say is that after the latest SB 37 and the changes in attorney advertising, there may very well be more advertising cases coming through the State Bar Court. This is just attached.
If you're not familiar with the rule, Aaron just cited the new law that's coming into place regarding advertising, which creates a private right of cause of action for consumers out there to bring a case against attorneys for false or deceptive advertising that aren't in compliance with the statute. You should familiarize yourself with it. Take a look at your firm's website and make sure you're in compliance. It's going to be really interesting how those cases eventually make their way through the civil court system. I think it implicates a lot of First Amendment issues, a lot of protected activity issues, potentially slap motions are going to come into play, but you really should familiarize yourself with that. If you have billboards and are advertising at that type of level, you definitely need to be familiar with the new law.
Yeah, just a couple points on that. What, Neville, do you want something? Oh, I thought you were going to say something about this, but the basic points are, first of all, unlike under Rule 7.1 and that series, where it's just basically anything that's not false and misleading, it pretty much goes as long as it's attorney advertising and either in context or identified as attorney advertising. Now, an actual lawyer has to be identified with each ad and a bona fide office. So if you're like saying you have like statewide reach, you have to have an office identification. And before you have that private cause of action, you have to make a complaint to the state bar. And the state bar has to take action on your complaint, which is interesting because the statute doesn't have any extra money for the state bar to process all these advertising complaints. So, like I said, they've never put a lot of emphasis on advertising cases to begin with. We'll see how that goes. Now, let's talk about the Eastman case. This case is actually not, it's still before the Supreme Court, but John Eastman was disbarred for a series of actions that were related to the 2020, or I guess challenging the election results in 2020. So this case, the review department, which again is the State Bar Court's appellate court level, found culpability on all 10 counts that the hearing judge had found, and the disbarment recommendation is right now before the Supreme Court in California. But I just wanted to let you know that's making its way. And this is another, I guess, for discipline nerds, interesting case. Joe Dunn was the prior executive director, and some more than 10 years after his term, the State Bar brought charges for they found, I guess, a misrepresentation to the Board of Trustees and imposed a 30-day actual suspension, which is actually, I think the review department decision has not yet come out. So I know Neville wants to talk about Chong.
Yeah, I mean, this is just an important case where the client wanted to get out of the deal, out of the fee agreement, got rid of the lawyer, and then went and settled the case. And the court said, but the lawyer had already agreed to basically the terms, but without authorization. Then the client came in and accepted the deal. There was litigation, and the law firm won on the basis that, look, you took the deal, you ratified it overall. So that was important there to know that happened, and that you can in fact get paid, because not the client here was trying to welch on the deal.
And I think a lot of components from this case are important. Number one, if you as the lawyer handle the case all the way through close to the final steps or the courthouse steps or whatever it is, there's another Martirosian case from years ago, you should be entitled to your full contingent fee if the case then settles and after the client fires you, like the client did here. One thing we're seeing a lot of as well, and it dovetails into referral fees, Rule 1.5.1, if you're not familiar with it and you accept or get referral fees, you need to have a separate document with the client's informed consent along with both lawyers at the time the agreement's made. And what we're seeing a lot of is cases that get inherited by a new firm and there's no referral fee agreement, but nonetheless the prior firm asserts a lien and they end up being heavily litigated between the two firms. And it's something that could be easily avoided at the outset, because if you're not going to acknowledge a referral fee or going to dispute a lien, do it right away before it gets to the end of the point in the case where you get a bunch of money and now you've got to hold up your fee in a trust account because there's a lien, and deal with all those issues. And so it's just something that we're seeing a lot more of on the civil side. And this is not something that's covered by insurance. It's lawyers are having to pay out of pocket to fight over fees, when a lot of it could be avoided. Now, look, you can't necessarily prevent a prior counsel from asserting a lien, no matter how many previous attorneys have been there. But I think the more you document it early on and dispute it, it's going to undercut it down the line when they ultimately file a lawsuit against you. And they also at the same time have to sue the client as well. But we're seeing these come up. And so I think, again, communication and documenting things with predecessor firms is really important. And if they are going to assert a lien, I think right off the bat, when they do so, request all the work that was done, right? They're generally going to be entitled to the reasonable value of their services and nothing more. So a lot of times big settlements come out, multi-million-dollar settlements, the prior firm did four things. They drafted a complaint, propounded some discovery, and took a depo, and they want, half the fee. Well, that's not necessarily what they're entitled to. So if you request what their hourly rate is, a reasonable hourly rate, even at $1,000 or an hour or some crazy rate that they want to choose, have them give you the backup of the amount of hours and try to resolve it early on before it ultimately leads to litigation. Because again, once it's there, it just starts eating into your fee, the money we have to spend to defend them. They can sit around for a long time, and predecessor firms can create a lot of problems with fees and ultimately grind you down, and you end up giving away money you probably didn't have to give away. So.
A very big area, because when you're a contingency fee lawyer, it's not simply amount of time put in and the prevailing hourly rate, because basically all of the factors that are identified in Rule of Professional Conduct 1.5, those 13 factors, some of them apply, some of them don't, but those are the kind of factors you look at when you evaluate quantum merit, because you're entitled to what the value of your services were. And one of those most important ones is results obtained. That's why this case, the Chong case, went the way it did, because what you're dealing with when you have attorney one and attorney two, like in this case, if attorney one already got, let's say, the whole policy limit demand made, let's imagine that case. The policy limits are tendered to the first lawyer, and then the client says no. And then the second lawyer spends another 6 months and gets the same policy limits demand. Then the second lawyer that might have churned the file, they might have done a lot of busy work, but they didn't get the results, because the first lawyer, if they got the policy limits demand, will, when you're apportioning the attorney's fees on a contingency fee, it's apportioned between attorney one and attorney two. It's never going to be increased from that. And that's a big issue. That's the Van Sickle case, which was a big discipline case. Even if you're the second attorney in line, let's say, and you have a 40% contingency fee, and it's, let's say, $100,000 or $1 million settlement, and there's $400,000 of attorney's fees, and you want to stand on, well, I have a contingency fee, I earned all of it. No, attorney one, or all the attorneys before, you all get to apportion whatever the total attorney's fees are. It never eats into the client's attorney's fees. So you have to be very careful if you're attorney two or attorney three. Is there going to be enough money to make sense for us to continue working on this case? Because we're likely to we're going to have to apportion it. But depending on if you're the one that got the results, then as that being a very major factor, that might mean, as in this case, the full contingency and fee was really earned by the first lawyer. And when you get a settlement, that's when the contingency is met. So you get a situation, and I'm sure Marshall's seen this, where the case is settled, client agrees to the settlement, and as an accommodation, the lawyer resolves liens because they're nice. But that's not part of their contingency fee. So if the client starts making trouble about challenging the fees to be earned by that lawyer, then it creates a conflict. And so what are you going to do about those liens? Then it's really for the client to have to deal with their liens and maybe interpleading the funds. But again, even if they get a second lawyer involved, if you've already gotten the settlement, that second lawyer doesn't get part of your contingency fee because you already earned it.
Don't you recommend that you put in the elements of 1.5 and say, here, if I'm substituted out, I'm going to get, as a floor, my hourly rate as against maybe perhaps more, depending on result achieved and the other aspects of the rule.
I think that's important to establish your lien. If you're the first lawyer, you should have in your retainer agreement a contractual lien provision. And if you put in the hourly rate that you are going to seek, that's very helpful, because the client's understanding and agreeing to that hourly rate and the contractual lien. So down the line, you've already checked one of the boxes off if you're going to be trying to get money in the event you get terminated as counsel.
Right, and I'll just want to raise another area that's tricky is there are, fee shifting statutes. And what happens when you have a case that's, say, worth $100,000, but you do $300,000 worth of legal work? then you have a potential, you have to advance, talk with the client, how am I going to handle this? Or if it's a case where it's a breach of contract and the prevailing party gets attorney's fees, commonly what happens is I get to make a choice as to whether I want to throw it all into one pot and take 40% of it or whatever the percentage is, or take just the attorney's fees section. But that could raise a conflict, I think, when you're settling a case, say under a statute that provides for attorney's fees, and the attorney's fees are much higher than the amount that the client's going to get. So I think, what do? I guess tell the client they can seek independent advice if they want.
No, I think what you do is, now what you should probably have in your fee agreement at the front end, it's at the attorney's election, either the contingency fee on the total recovery, lumping in the attorney's fees, or at the attorney's election, the statutory attorney's fees. But you can.
I'm just saying it gets tricky when you're settling the case, and you've got 300 grand in attorney's fees and 100 grand for the client overall. If you can get the client to agree, okay, fine. But sometimes I think the client's going to say, hey, wait a minute, maybe you cut me in for some of that amount that you're going to get as well. That's just the realities of life.
I don't disagree. And I've actually seen, and I don't know what Marshall's opinion would be on this, not only at the election of the attorney, or I've seen and in some contracts.
Yep.
Basically statutory attorney's fees and my contingency, which I would say probably is a violation of the conscionability rule 1.5. But so far the State Bar hasn't taken any action on that directly, as far as I've seen.
All right, let's get into AI. That's a fun topic.
Okay. Yes.
Fun stuff. So I probably spoke on this, I don't know, 18 to 20 times last year. And it never ceases to amaze me that lawyers are still misusing AI. At this point, it's a great tool. It's here to stay. It's fully ingrained in all of our practice areas. It doesn't matter what you do. Lawyers are using it. Other types of companies are using it. I was just on the AAA website and noticed that they now have an AI arbitrator, fast, cost-effective, and trusted dispute resolution with an intuitive, easy-to-use platform. So ADR services, all these companies may be using it. AAA is advertising that you can now have an AI arbitrator. I think there's still a human component to it, as they indicate, but nonetheless, you have to know how to use it, and you have to know when it's being used against you, because it's extremely valuable. And if you look at Rule 1.1, if this is the first time you're attending a seminar regarding AI, you're honestly a little bit late to the game. You should be aware of this, because this rule dictates that we're all required to be competent with respect to a number of things, in particular, emerging technology. And so if you leave this seminar, if nothing else, start to dabble in AI. There's a bunch of other seminars I've done with the Beverly Hills Bar Association where we talk about various applications that can be used. If you're a litigator, if you're a contract transactional attorney, there's companies that offer so many different types of services, and you can start to learn about what might benefit you and your service. For me, I use artificial intelligence for trial work, a lot of creative issues, themes, cross-examining witnesses, all sorts of things come up. And it's just another tool in my tool belt to effectively represent my clients. We do not use artificial intelligence for briefing or anything like that, because obviously I think the work product we put out is far superior. But also, if you go to the next slide, there's the ABA formal opinion 512, or you can go one more.
Oh my goodness.
It's okay. Sorry. It's all right. It's the we have a different PowerPoint up, so I'll go from memory here. So there's an ABA formal opinion 512, which is the first ABA opinion really that addressed artificial intelligence and the risks that came out from it. And you should all be familiar with that opinion. It talks about a number of things. It's very useful to you to use how to guide yourself in dealing with artificial intelligence. I think a couple key points here are, number one, if you have a firm, even if you're a sole practitioner, it's useful to create a firm policy regarding AI. If you're the managing partner of a firm or a partner of a firm and you oversee younger lawyers, you definitely, and you're allowing the use of AI, or you don't know whether your younger lawyers are using it, you definitely want to have a policy, because California Rule of Professional Conduct 5.1 states that a lawyer who has managerial authority in a law firm is required to ensure that the firm is giving reasonable assurances that all lawyers are complying with the state bar. And so it's real easy to create a simple policy identifying when AI can be used, when it can't be used, who can use AI, how it can be used, all the different things. And you can limit it as much as you want. But when you look down the line, and I already have 2 cases now in the civil court arising out of malpractice claims for the use of AI. I was honestly a little bit surprised at how quickly I got those cases from the time AI has really taken off in the legal field. But they're here, and there's only going to be more of them. And so if you have a policy, it really creates a nice framework for you to defend a claim that says, look, this person either violated the policy or did something, went rogue, wasn't allowed to do it, whatever it might be. But in both matters I'm dealing with, there's no policy. It was too early. No one knew what was going on. And obviously, they used AI inappropriately because they were sort of ignorant of how to use it. And it spit out cases where hallucinations occurred and the cases were fabricated, and now there's problems to deal with it. And I'm sure if you haven't heard about it, and it surprises me how many lawyers are still getting into trouble over this, because it's not just in the Daily Journal that it's reported, it's in the New York Times, it's in the Wall Street Journal, it's all over the place. Firms nationwide are getting sanctioned more and more because they use artificial intelligence to draft briefs, which undoubtedly hallucinate and create cases that don't exist. Or not even that, it might cite a case that exists, but misconstrues a holding within that case. And a lot of these companies that are out there, for instance, Westlaw, Lexis, we know about them. They all offer an AI component. And a lot of them advertise that it's hallucination free. And what that means is they're using their artificial intelligence is built on a closed network. It's built on just the data that they choose to feed it, which is reliable data, right? It's treatises, it's case law, it's all the things that Westlaw traditionally has. It doesn't allow it to feed from third-party websites, Reddit, things that ChatGPT and other open source AIs allow the information to come from. But the issue that's come up even when using Westlaw is, well, you're going to get a case that's valid and it's not going to make it up completely. It might misconstrue the holding. It might pull from the dissent of an opinion and get confused and give you a holding that you think, aha, I can cite this case. I know I'm safe. It's in Westlaw or Lexis. But if you don't check it to make sure, and then you file that brief and you intentionally misquote a case, you can get yourself into trouble that way. And there was a recent Court of Appeal opinion that came out here in the state of California, and they made the opinion published only for the reason that the lawyer used artificial intelligence on appeal. Right? The actual appeal had no reason to be published. It was just a meaningless decision, nothing of merit, but they published the decision solely for the reason to basically, chastise this lawyer in public. And then they took the decision and sent it to the state bar. And in the decision, it says this decision is being sent to the California State Bar for disciplinary proceedings. I mean, that's how seriously these issues are. And that's how careful you have to be. But again, I'm a big proponent of it because it's here to stay. And if you're just going to say, I'm never going to use it, I'm never going to look at it, I do not think that is the right approach at all. And one of the more extreme examples that have been used to date, and I think this is just shows where it's going, is there was a criminal case, I believe in the state of Arizona. It's called the Pelkey case. And this was a case where a criminal case where the victim was deceased. And at the victim impact phase of the trial, which again, there's no jury present for this, right? This is just a victim impact statement that's being made to the court for determining sentencing. They created a artificial intelligent victim impact statement. This was video and audio. So the judge literally saw the deceased person give a victim impact statement of compassion, of accepting apologies, whatever it may have been, that occurred. And the judge was quoted saying, among other things, "I loved that AI." And then the criminal defendant was sentenced to 10 and a half years in prison, which was in excess of what the prosecutors had sought for punishment. Now, that case is on appeal, okay? And it's going to be very interesting to see what happens with that case. But it's really, really important to understand that's how creative lawyers are being with artificial intelligence. And so if you're in depositions, if you're dealing with things, you need to start to learn how to ask questions about whether or not artificial intelligence was used by your clients, right? Because now your clients are clearly using artificial intelligence for emails, whatever it might be. You need to understand there's a whole new world and line of questions that have to come out through discovery and things like that, attacking and understanding the use of artificial intelligence. So again, you really just need to learn about it. The California legislature is also playing catch up, right? And it makes perfect sense. And in one regard, there's a new bill, AB 2013. And if you're a firm or an individual who's taking artificial intelligence and modifying the platform to conform to something you want, like if you're really creating your own AI, and plenty of firms are doing this, they have taken it on themselves, they're creating workflow systems, whatever it may be, you are required to now disclose that to the public as to what your particular AI platform is. And so again, that's just a rule if you're ahead of the game and adopting it. And a lot of plaintiff big firms I know about have their own types of AI systems to manage cases, to deal with demand letters, whatever it might be. You've got to be aware of AB 2013.
I should mention that, as I understand it, ChatGPT is public to some degree, and it can be discoverable if you're using it. And you may want to be on another platform that does not disclose what you're working on. I think Claude is one that does it that way as well. But that is a very troublesome area if you're trying to keep private whatever it is that you're researching. I should also mention I've had at least 5 clients in the last 3 weeks come in and say, here's how we're going to win this case. I did it on ChatGPT, and I have to tell them, hey, I got to tell you something. I went to law school, and that is not what fraud is in California. So be very wary. And clients are showing up with pleadings. Here's the complaint. I've drafted it myself. It's a whole new world.
Yeah, and look, plaintiffs are going to get to do these types of things. There's a couple of questions I want to hit real quick. Yes, the victim impact statement was AI generated, voice and image. There's another question. Do you consider it unethical for an attorney to double book a trial without disclosing the schedule conflict to both clients and not offer an opportunity for a continuance? I think that if you just have to be able to represent your client zealously and competently, right? And oftentimes trials get scheduled not necessarily on the same day. I have trials scheduled sometimes 10 days apart. And I'm confident that I can deal with those schedules effectively. A judge can only force you to be in one trial at a time. And generally speaking, the older case is going to go first. So while you might have 2 trials on the same day, you're a little bit of a glutton for punishment. I don't think there's anything unethical about it unless you can't effectively prepare for those trials at the same time. You probably should let your clients know that this has happened and you're going to try to deal with it. Which I think you should do. And then this question, I think, Aaron, you should hit, which is if you receive funds in your trust account and the client dies without a will, preventing distribution of client funds within 40 days, what is one required to do? Same question if there are claims or lien against the funds.
Okay, well, you only have to distribute undisputed funds within 45 days. So but it's on you because it creates it, not having money in your trust account distributed within 45 days of receipt creates a rebuttable presumption that it wasn't promptly, unless it's you have to either prove that the money was disputed or other good cause. So the fact that the claimant has died and there's no probate from which you could just pay the money into would establish good cause. But it's up to you to have to be able to prove it, because that's one of the things that the changes to Rule 1.15 did, which is basically to create that rebuttable presumption in a discipline case. So it's up to the lawyer. So you're the one that has to prove that, oh, if there's liens, et cetera, against those funds, the face value of the lien is disputed, but you have to show that you're taking diligent steps to distribute the funds. So if you can no longer probably safely continue just to do lien negotiation orally, you're going to have a component of it documenting those efforts to resolve the liens to show why you weren't able to do it within 45 days. And just to tag on one moment about the AI issue, I would 100% agree with Marshall. It's here to stay. So the answer cannot be, if you're an older lawyer, I don't use AI, because you may not use AI, but your associate, you could believe does. So to say, oh, you don't do that is just like telling I'm not going to text your client. Of course you are. So this is the kind of policy that I would say is the no nonsense policy, because even though your associate drafted that document, you're the one signing it. So you're the one that would be sanctioned, even if you didn't even know how that competent, lawyer has her own license did. So what you have, this is the policy I would suggest, that with every single pleading someone prepares for you or letter that has any case law, that they also have a link in a folder that they pulled the actual case off of Westlaw, or if you use Lexis. That way, and if they quoted any language from a case, they have to highlight it. Because then it's easy to go back and for you to check and make sure everything's good. And that way they can, even if they drafted it with AI, they had to go do the checking themselves in order to pull all the cases. And a policy is important, but training is also important. So what you should do is that periodically, document that you've done training on whatever your policies are, including AI, and have your staff sign off that they got that training, because that's how you're going to prevent a case being brought up against you by the state bar for lack of supervision, either of your non-attorney or attorney staff.
All right, well, our hour is up. I'll just say one other final thing for all practitioners out there is, when you have a case where your client could get hit with attorney's fees on the other side, either because of contract law or fee shifting, or for example, anti-SLAPP, make sure you let the client know that that is a possibility and have them sign off on that. I want to thank Marshall Cole and Aaron Joyce for participating in this, and all of you for hanging in there and watching this to the end. Thank you very much.
Thank you. Bye.
Thank you.